Thank you. So the final step in the judicial process, so enforcement, is essential for making sure that the court decisions are upheld in real life and not just on paper. So when a court issues a ruling, it recognizes someone's right to a specific outcome like financial compensation or property rights. But without proper enforcement, these rights remain empty promises with no real impact. And so enforcement, therefore, is a key connection between a court's decision and real justice. So in our rapidly changing tech-driven world, traditional enforcement methods need to evolve to stay effective and accessible. Enforcement actions such as seizing assets, garnishing wages, or following specific court orders must be fast and accurate. Outdated processes can be slow, can be expensive, and complicated, creating obstacles for people trying to claim their awarded rights. So today's presentation will focus on ways to make judicial enforcement more effective and more accessible. We'll discuss how technology, how data insights, and new methods can make enforcement quicker, clearer, and easier for everyone. For instance, automated systems could track assets and manage cases digitally, reducing paperwork, while AI could help prioritize urgent cases or avoid prescription. We'd also talk about challenges such as handling enforcement across different countries, which is increasingly important in our globalized world. As more people and businesses operate internationally, cross-border cooperation in enforcement has become a key concern. The aim is to spark discussion and inspire efforts to modernize enforcement so that rights granted by courts can be trusted and practically enforced. By working together and embracing innovation, we can create an enforcement system that keeps pace with today's world and truly supports justice. So, innovation in judicial enforcement. Enforcing court decisions is often seen as a slow and costly process, but there's a great potential for improvement. With new technology, enforcement can become faster, more affordable, and easier to access, helping the judicial system to deliver fair and effective justice. And today's innovations are changing old, paper-heavy methods into quicker, more efficient processes, improving communication between everyone involved or allowing for smarter, data-based decisions. Let's talk about digitization. The digitization of judicial files is a cornerstone of modern enforcement innovation. By converting paper records into digital files that are accessible in real time, case management systems enable judicial officers, and by the way, if I'm talking about judicial officers, I would like to say that we don't like the term bailiff. We are usually using the term enforcement agent, enforcement officer, or judicial officer, but not the term bailiff. So it enables us to obtain up-to-date information on cases at the click of a button. Digitized case files reduce dependency on physical documentation, minimizing delays caused by need to locate, to retrieve, and manually review records. Real-time updates, for instance, through intranet web access for all stakeholders, including our clients and including debtors, allow all stakeholders to stay informed of case progress, reducing the time and the cost that is associated with sending, tracking, and filing physical documents, as well as exchange of letters between all the stakeholders. For enforcement officers in particular, immediate access to case information can help to prioritize case based on urgency and risk, ensuring that resources are used effectively. Let's talk about automation. Automation is now a powerful tool transforming judicial enforcement. Automated systems streamline routine tasks such as data entry, sending reminders for payments, and generating routine correspondence, freeing up judicial and legal professionals to focus really on tasks that require human judgment and expertise. Automation of procedural tasks not only accelerates case processing times, but also reduces the chance for human error. For instance, in enforcement cases requiring routine communication with debtors or third parties, automated notifications can ensure timely compliance, improving the chances of successful resolution and reducing follow-up requirements. By taking over repetitive tasks, automation empowers legal professionals to direct their attention to complex cases that truly benefit from their experience. Standardization. Standardization in data entry and case documentation is essential for improving consistency and accuracy across the enforcement process. By establishing uniform protocols for how information is entered and organized, judicial systems reduce variability and the risk of misinterpretation, which can otherwise lead to delays or errors. And standardized templates for reporting, case filing, and record keeping facilitate seamless communication between the various stakeholders, including judges, including lawyers, and of course, judicial officers. When data is organized in a predictable, structured format, it can be analyzed more effectively, enabling the judicial system to draw insights from enforcement data on case outcomes. For instance, sometimes we receive judgments where we have to ask the judge to interpret it because we don't exactly understand what he's meaning. So additionally, standardization promotes greater interoperability between different stakeholders, supporting collaborative efforts in cross-border or multi-jurisdictional cases. Let me come to centralized databases and data analytics. Digital tools like centralized databases are valuable in modern law enforcement. These systems gather all case information in one place, giving approved users an easy, complete view of data they need. And this setup makes data clear and allows enforcement professionals to follow cases from the start to finish without switching between different systems. Centralized databases, of course, support decision-making based on data as they show past case trends, success rates, and common challenges. For instance, analytics tools can reveal the average time it takes to resolve certain cases or highlight factors that lead to successful enforcement. These insights help judicial officers to improve the enforcement process, direct resources where they are most needed, and adjust practices to enforce more efficiently. Allowing judicial officers access to data helps to identify and to track debtors' assets. And that can be, of course, very beneficial. With the right data access, judicial officers can locate and verify a debtor's assets more effectively, which is often essential for the successful enforcement actions. And this access might include viewing information on property ownership, on bank accounts, on vehicles, or other assets tied to the debtor. And having this information available in a centralized system saves time, as judicial officers don't need to search through various databases or request information from different departments. It also helps to reduce errors, ensure that decisions are based on an accurate and up-to-date information, and it speeds up the enforcement process. Of course, this type of access should be carefully managed to protect privacy and ensure that data is only used for legitimate enforcement purposes. We need also to learn from international best practices. In a globally connected world, learning from the successes of judicial systems in other countries is a valuable strategy for improving local enforcement practices. For instance, judicial officers that have implemented automated case management system or advanced data analytics can offer guidance on best practices and effective deployment strategies. Countries with well-established digital enforcement systems, such as, for instance, the Baltic states, have demonstrated the impact of technology in expediting case resolution and improving access to justice. By studying these models, judicial officers can adapt and apply successful strategies to local context, tailoring solutions to meet the unique legal and social needs of their country. And additionally, cross-border cooperation is increasingly critical. In a globalized legal environment, international disputes increasingly demand cross-border cooperation, especially in enforcing foreign judgments and serving documents. Collaborative technology and frameworks for data sharing across jurisdiction improve both the efficiency and consistency of these processes. Although the EU provides a unified legal framework for cross-border service of documents and enforcement, its application varies significantly between countries. Notably, some countries still do not accept electronic transmission of documents, particularly where direct transmission between judicial officers is not permitted and the state entity must act as an intermediary. In these cases, postal services are still required, causing delays that can be costly in terms of time. To illustrate personal case, in mid-August, I transmitted a summons to appear to court to a foreign receiving entity for a court hearing that was scheduled in October. While the summons was served in early September, well, within the time frame, the completion of the service certificate took an additional 2 weeks, followed by 3 weeks in transit via postal service. So unfortunately, the certificate arrived after the hearing had already taken place. So that means rendering it too late and requiring the process to be restarted. So this is absolutely unacceptable. There is a need for modern systems. This is undoubted. Many judicial offices are burdened by outdated, task-specific software systems that are incompatible with today's demands for integration, for cloud computing, and for data volume management. Local server management not only requires significant resources, but also hinders scalability, efficiency, and also secure collaboration. In today's high-tech environment, judicial officers must adopt cloud-based solutions, which offer more security and more efficiency. And these systems furthermore simplify regulatory compliance. And if I'm talking about regulatory compliance, of course, we have the GDPR. In today's world, updating technology isn't just a smart choice. It's necessary to meet strict rules. And as more stakeholders use digital tools, they must follow more regulations to keep data safe, protect against cyber threats, and ensure that AI is also used in a responsible way. Key rules like the General Data Protection Regulation, so the GDPR, the Network and Information Security Directive 2, the NIS2 directive, and the upcoming AI Act set high standards for data privacy, cybersecurity, and also ethical AI use. And these rules are important in today's digital economy, where data is valuable but can also be risky if not managed well. The GDPR, which applies to everybody handling the personal data of EU citizens, is one of the most rigorous data privacy laws globally. It requires organizations to adopt comprehensive data management practices, ensuring that personal data is collected, processed, stored, and shared in a manner that respects individuals' privacy rights. Key requirements include data minimization, where only the necessary data is collected, explicit consent for data use, and the right for individuals to access or delete their data, known as the right to be forgotten. To comply with GDPR, judicial officers must modernize their data handling practices by implementing sophisticated data governance frameworks, and this often involves adopting secure data storage systems, enhancing data encryption, and also employing access control measures to restrict data access only to authorized persons. GDPR compliance also necessitates frequent audits and the establishment of data management roles such as a data protection officer, the famous DPO, to oversee data privacy practices. Failing to comply with GDPR can result in severe fines and reputational damage also for our profession. The NIS2 directive. The NIS2 directive mandates organizations and professionals in essential sectors, including the sector of justice, to adopt a robust cybersecurity practices. And these include incident reporting, risk management, and implementing specific measures such as network monitoring, vulnerability assessment, and incident response protocols. Compliance with the NIS2 requires judicial officers absolutely to modernize their cybersecurity frameworks to achieve a higher level of threat resilience. Last but not least, the AI Act. The AI Act, which is currently under development in the EU, sets forth a regulatory framework for the ethical and transparent use of AI technologies. The Act categorizes AI applications by risk level ranging from minimal risk, such as spam filters, to high risk, such as, for instance, social scoring systems. And this is something of which judicial officers might be concerned, because we evaluate the solvency of someone, so we score someone. So high-risk AI systems, particularly those used in critical sectors like the enforcement, must meet strict transparency, accountability, and oversight standards. And this includes ensuring that AI decision-making processes are also explainable, that data that is used to train algorithms is free from bias, and that AI systems are continuously monitored for unintended outcomes. In other terms, the last decision belongs to humans. A profession that embraces modernization to meet these regulatory standards are better positioned to navigate the evolving digital landscape. There is an urgency of modernization. Given these challenges, the modernization of processes is not a mere option. It's crucial to survive in today's competitive and regulated environment. Also, change can feel overwhelming. Adopting new technologies is a key of making work smoother, lowering risks, and staying within the regulations. Modern technologies, particularly digitization, automation, and artificial intelligence, offer practical, proven solutions for addressing these challenges. We have to move forward, but we have to move forward with caution. While the benefits of AI and digitizations are clear, it's important to recognize that technology is not a silver bullet. The marketing of AI has become increasingly aggressive, often portraying it as a cure-all for all operational inefficiencies. But it must be implemented thoughtfully, with careful attention to the specific needs of judicial officers. Not every challenge requires an AI solution, and over-reliance on technology can also lead to its own set of problems, including overcomplicated systems, high costs, and of course, potential risks of non-compliance if not properly understood. But even if we have to move forward with caution, the time to act is now. This is a pivotal moment for judicial officers. The rapidly changing legal and regulatory landscape, combined with technological advancements, provides the perfect opportunity to rethink office organization and inject fresh energy into operations. Modernizing our practice doesn't just improve efficiency, it positions us as a leader in the field, prepared for the future. We must learn about practical, real-world solutions that can be immediately applied to our daily operations. We must gain insights into how digitization and automation can help us to navigate the current challenges and future-proof for our business. The growing adoption of artificial intelligence and automated systems in legal processes poses for such numerous challenges, but also offers opportunities. And the issue of respecting human rights in an automated legal environment is central and raises ethical, legal, and technical concerns. One of the main concerns in that respect regarding AI in legal processes is the lack of transparency and explainability of the algorithms that are used. Automated decisions must be understandable to the individuals affected, and especially when they influence fundamental rights. And here I'm thinking about Article 6 of the European Convention on Human Rights, the right to a fair trial. But I'm also thinking about Article 8, the right to privacy, family life. So AI systems, especially those that are based on deep learning models, are often seen as black boxes due to the complexity of their internal decision-making processes. To guarantee human rights, it is essential, in our own humble opinion, to document the decisions that are made by those algorithms to allow human verification. But above all, the algorithms must be made explainable so that the concerned parties and all the legal actors can understand how the AI's conclusions are drawn. AI systems are sensitive to biases, especially those stemming from the data that has been used for their training. If an algorithm is trained on biased or incompleted historical data, this can lead to discrimination. Let's talk about responsibility. In an automated setting, responsibility becomes more complicated and depends on factors like how the AI is used, the laws in place, and how the AI was designed and deployed. Who is accountable when the AI makes a mistake? Could it be the designer, the provider, or the authority or the judicial officer that is using it? If the error is due to flaws the AI's design, like programming mistakes, poor data choices, or bias, the designer or the developer might be held responsible. The company that sells or provides the AI could also be responsible if it doesn't clearly explain the system limits or provide proper support for correct use. The end user, such as the judicial officer, the enforcement agent, may also be responsible, particularly if he misuses the AI or uses it in a way it wasn't designed for. So to handle these issues, a clear legal framework is needed to set rules on who is responsible for AI-related damages, along with easy ways for people to contest the decisions that are made by machines. And here we come to the human oversight and the judicial control. Automated systems should not operate without an adequate human supervision. Human oversight is essential to ensure that decisions that respect not only the law, but also ethical principles and human rights. Continuous training for judicial officers on new technology and their implication is, in that respect, essential. Ensuring human rights is in an automated legal environment requires a proactive and a multidisciplinary approach. This necessitates clear regulation, constant human oversight, ethical design of technologies, and robust mechanisms to protect against abuses and discrimination. Automation could help people access justice by making legal services quicker and cheaper, but there's also a risk that it could increase inequalities if some people can't use automated systems due to a lack of digital skills, but also due to a lack of financial means. Let me come to my conclusion. In conclusion, we believe strongly that judicial officers play a vital role in upholding social harmony and ensuring that justice is accessible to everyone, especially the most vulnerable in our communities. Through their commitment to fairness and impartiality, judicial officers help maintain trust in the justice system, and through their presence in the field, and here I repeat, judicial officers are the only legal professionals that are really in the field and that are really in direct contact with the debtor. We act as a bridge between justice and the citizens. We explain in simple language the terms, the legal terms that are mentioned in a judgment and that most of the litigants don't understand. It is this human element, this understanding, empathy, and dedication that gives the profession its strength and sustainability in a constantly evolving world. And in today's rapidly changing landscape, with new technologies, evolving legal frameworks, and organizational pressures, judicial officers remain central to the justice system. They are the ones who bring a human touch to the procedures that will be dominated in the future more and more by automation and technical processes. By balancing these technological tools with human judgment, judicial officers ensure that advancements in efficiency do not overshadow the importance of empathy and fairness. As guardians of justice, judicial officers do more than just enforce court decisions. They uphold principles of equality, of respect, and of accessibility. Their dedication to justice is what keeps the role of judicial officers essential. By working together, promoting interprofessional collaboration, and supporting innovation in our offices, we can not only strengthen our profession, but also ensure the respect of fundamental human rights in an automated legal environment. This is how we will be able to build a justice system that is not only efficient, but also fair and inclusive, respecting the needs for all without any exception. Thank you so much.